Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello, and welcome back to the Business Law, Estate Planning, and Estates podcast with attorney Thomas LaPorte. Thomas is the founder of LaPorte Law Group, PLLC, practicing in New Hampshire, Maine, and Massachusetts, with offices in Portsmouth, New Hampshire, and Andover, Massachusetts. With more than 30 years of experience, he helps individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. I'm your host, Lisa Mosbey, and today we're talking about the legal leading risks established private businesses face, including contract exposure, intellectual property issues, litigation risks, governance concerns, compliance obligations, cyber threats, and how companies can reduce those risks before they become expensive disputes or operational problems. Thomas, thank you so much for joining me again today.
Thanks, Lisa. Good to see you.
Thomas, what are the leading legal risks to smaller and privately held companies?
Well, I guess it depends on the sector or the business, but I'll focus on a couple of them and touch upon a third. I guess uniformly, the leading risk, I believe, comes from just poor contracts, informal drafting, use of contracts that perhaps were given to them, inherited by them, obtained from the internet, and whatnot. And I'm not trying to shill for folks to go to an attorney, but you go to a good business attorney, he or she is going to identify, your objectives, your business risks, your business relationships, the relationships you're trying to establish with your business partner, and prioritize with you after identifying the risks within a contract, how to minimize those, what to push forward on, what to concede, those types of things. So the first one has to do with poorly drafted, poorly managed, and poorly enforced contractual provisions. They could be vendor agreements, they could be end user consumer agreements, they could be distribution agreements. Whatever agreements or contracts companies use, you ought to try and create maybe not the Uber contract for your company, but a contract that is largely to your liking. It's your base from where you start, and go into business in the stream of commerce with those agreements so that you sort of have the leverage. Your risks are reduced, your costs are reduced. I think that's the first one. IP, intellectual property, is becoming more and more a problem, and it's really nothing new. But states now are requiring written internet security protocols, not just for medical companies that deal with private health information and are subject to HIPAA. It's personally identifiable information, people's social security numbers, even their business ID numbers, bank accounts, financial data, things of that. There are folks around the world, including state actors, that find that information valuable. So businesses have to be aware of those issues and take some reasonable steps to minimize the chance of disclosure.
And I know there are many, many more, but those leading risks, how do companies get a handle on that? Where do they start to manage those risks?
Speaking with mentors that perhaps have been in your business, and you'd be surprised that people like to help other people. Now, companies compete with each other, but there's also very good business attorneys out there. There are very good. There are accountants that specialize with businesses and know how to structure deals. More of the maybe not day-to-day type contracts, but if you're emerging, if you're going to be selling assets, selling your stock or your membership interest in LLC, there are professionals out there, not all of whom are very, very, very expensive, like folks in New York and the largest cities, that can help you. And I think speaking with one or two and getting aligned with those people, put them in your stable of resources, can reduce the contract problems that I had alluded to earlier. And there's other professionals too, not all of whom are needed, but there's HR professionals, for instance, and that's fairly important. You don't have to have HR on staff, but there are companies out there recommended by an outfit called SHRM, by the way. These are SHRM certified. Don't ask me what that stands for, SHM something, certified HR professionals that can help with your sexual harassment policies, which are required, your handbooks. I've done some of those. So there's a lot online. There's even payroll companies that prepare handbooks. I would say, however, when you get documents from those types of companies that are not necessarily lawyers, run it by your attorney, because there are provisions I've found that have been omitted, like those that were imposed by the National Labor Relations Board before it changed hands with the current administration. There were certain provisions that needed to be in there, which has been suspended in the last year or two. But that's just an example um, for business to consider.
What risks are these companies related to? Management of internal governance? Are some companies exposed to, whether they are fully aware of them or not?
Well, dependence upon one decision maker or a small cadre of decision makers almost inevitably can lead to significant structural issues within the company, dissatisfaction um, amongst employees, particularly those that have been there for quite some time and feel that they've contributed to the growth of the company. They're not heard. They don't have a say uh, in certain decisions, like the direction of the company. They may feel that they should at least be on some sort of track where they uh, acquire some ownership in the company. And the second problem, when the company relies upon a sole decision maker, for instance, is that person can leave. That person can become suddenly ill or disabled. Um, that person could get divorced, and now the company is an asset it's on the table in the divorce as part of the property division. So all of these problems can be avoided, frankly, with a fairly simple agreements done in advance. And if they're not done in advance, then they can be put in place now as a standalone document, as an amendment to your bylaws, to an operating agreement, to a partnership agreement. There's various ways that, as long as you get it in writing and it's agreed to in advance, when people are thinking reasonably as to how we're going to deal with uh, a key person leaving. Insurance can be bought for fairly cheap premium dollars, which will fund a buyout, for instance. There's lots of solutions to these very avoidable situations that arise from, uh, a singly focused decision source.
I think the obvious answer there is diversify, right? You mentioned a number of different agreements or insurance that can be put in place. Um, is there a specific agreement or more information that we could share with the audience about what type of agreements would be involved?
Two things there: agreements and also insurance coverages. I think you mentioned there are buy sell agreements, cross purchase agreements. There are redemption agreements where the company will buy back a departing or retiring key person, if you will. Um, there are certain, as far as putting in place a succession plan. It could be, it's not just family business out there, but there could be a succession plan where key employees will be assigned stock. While various milestones are met, called the vesting schedule. Um, as far as insurance goes, because I don't want to overlook insurance, the importance of insurance. Companies ought to, number one, we all need general liability. We all need workers' comp. It's required by the state, workers' comp. We really ought to have cyber risk security, whether it's included in your general liability or a standalone policy. Employment practices liability is something to consider. It's not that expensive, what I understand, for those who have employees. And then there are insurances. If you have trucks and vehicles that are used, you need to have commercial auto coverage for non-owned and hired automobiles. Your personal policies will not cover company vehicles or vehicles used in company business. Um, if you're in construction or you're in design, or if you're in professions where you're giving out advice like I do, errors and omissions and professional liability coverage, um, builder's risk coverage for those in construction. There's types of specific coverages are out there that are tailored, designed for depending on what type of company uh, you are operating. And similar to what I said earlier, getting introduced to a good commercial lines agent with an agency that has access to a lot of carriers, because you want diversity, like you said earlier, diversified, that usually drives the price down, um, is important. You don't want to have insurances out there, whether your business partner is requiring you to have, $5 million of coverage for this for 10 years. That may be excessive, and that can be negotiated down. It's either not needed, or it's excessive for the amount in controversy, the amount of the contract, the amount of potential risk dollar wise. And sometimes it's unreasonable to require those policies to be held for too long a time, say beyond the statute of limitations, if that might, that covers errors that arise out of what a product or service they were providing as a business. So, all those things ought to be reviewed with your contracts with a good commercial lines agent, and oftentimes they will work alongside your business attorney. And once you get it done once, a lot of this advice can be incorporated and used over and over again. So it's not going to be an ongoing cost to the business.
And Thomas, what about risks from regulations and compliance requirements? Perhaps those that companies may not know apply to them.
If a company, there are state requirements, not only in the statutes, but also in the regulations, which are also law. In New Hampshire, there are divisions of the regulatory code or the administrative code that apply to naturopath doctors, for instance. They apply to architects. They apply to businesses that are in the transportation business. And there's a lot of them. So businesses as well as people they're imputed. The state and the laws are imputed to people, and meaning that you may not have actual knowledge of all of them, but you're imputed with constructive knowledge of them because they're published. They're published, so you get a chance to read them, and therefore you need to know them. And that includes the regulatory types of things you're alluding to. There are regulations involving obtaining financing. There are regulations regarding taxes, of course. So when there's taxable events like sales of businesses, capital gains issues, not only at the state, but also the federal level. If you're building buildings, and I've said that a few times today because I represent folks that design and build buildings rather, and structures where people are going to be. There are very strict state by state control and supervision requirements. A licensed AIA architect, for instance, has to supervise the designing of plans. Those are some examples. It also applies to have clients in the medical field, and they're very, very stringent regulations regarding handling of patients' information. You can't send them to a Gmail account, for instance. So those are some examples, and they're everywhere.
One that we see a lot is with employees or people that we're working with. How do we mitigate employee or people related HR risks?
It's a really good question, and I'm dealing with one right now. And by the way, employee generated problems don't end at the door to the business. We've got glass door reviews online, and there's a whole issue of free speech online. And employees will put these glass door reviews and talk about your company, whether it's true or not. And it's difficult because it's just the gargantuan level of people online that the courts can't keep up with it. So, well, it's free speech. And it's very, very difficult to sue an employee for defamation. If there's a scintilla of truth to it, and the cost of doing so is just prohibitive. So having clear written policies, if there are problems, the that employees have. There needs to be clear reporting structures. They need to know who they can come talk to immediately. Those people have to be available. The problems have to be documented as well as the response. I believe that having at least another witness in certain circumstances uh, for both parties, so that they feel that they're being heard and they're not being sicked upon, for instance, by management. Um, those go a long way, and those policies have to be published and uniformly enforced. Nowadays, most companies' handbooks or manuals are online. They need to be updated. I have my clients have their folks sign off that they're read and they've acknowledged it and they understood it. I give them they're given enough time to do so. Um, One other thing that's been a big issue over the last 10 to 15 years is the distinction between employees and independent contractors. California, as well as Massachusetts, are have led the way to sort of do away with the independent contractor, with some exceptions. Real estate agents, construction, general contractors, use of subcontractors. Those are a couple of exceptions, but by and large, if those servants in a master servant relationship, the employer being the master and the servant being either the employee of the independent contractor, by and large, are going to be considered employees entitled to benefits, entitled to workers' comp insurance. You need to have paid payroll tax on these folks. And the rationale that states are given is that, well, the companies that use independent contractors, quote unquote, well, they're saving about 30%, and it's unfair to the companies that do use employees. That's the official rationale, but there's also a big revenue component as well. The states get their tax revenues. The states oftentimes are controlled of the workers' compensation company. Like California, it's a state-run enterprise. They're getting their premium dollars. So um, there's a yin and yang. There's a more acceptable reason, then there's more revenue-driven reasons under the guise of protecting employees, um, employee rights, and whatnot. They're entitled to talk about organizing during business hours, and employees have to be aware of that. Um, so, getting in touch with a good HR professional or a good business attorney that has employment experience, I've done that for quite some time, is worth your while.
And we just touched on the leading risks for some of these companies. There's so many more to discuss. What should companies look for in a good legal counsel to help them navigate this minefield, if you will?
Well, I think good legal counsel is not just going to take your contracts and be a legal theorist and create the Magna Carta of legal uh, perfection. It doesn't often work in a real business relationship. That business attorney really ought to understand the relationships you have with your counterparts that you're entering into contracts with. Sometimes they're new. Sometimes it's a large client or source of revenue that you want to get in good with. So in the beginning, the attorney should be able to prioritize with management, what's a CEO or whoever's handling the contract on behalf of the company, to identify, okay, where can we concede, where do we want to push back on, and to make a priority of those items. So a good legal counsel, a good business attorney uh, should understand uh, business in general, the real life um, variables that are at play when you're contracting and then operating pursuant to a contract. Um, we You don't want to be a pigs being led to the slaughter, but you don't want to be unreasonable and intractable so that you do not get the business. You want to be seen as a respected business partner. You want to prevent risk. That's also respected by good business counterparts. And good legal counsel can help you do that. And lastly, good legal counsel is accessible um, for quick questions because things move quickly, not just during major crises.
And Thomas, as we end today, would you like to share how people can reach out to you if they'd like to get in touch?
Sure. I'm online. My website is laportelawgroup.net. And my phone number is on there, both the firm phone number, and I believe my direct's on there as well, but it's easy to get a hold of me. My email address is on there. Folks can book 15 minutes if they wish, and speak with me. I will not charge them. We can at least get a handle on your issue. And if if it's proper to go forward with me or somebody else that I know in my world, in the legal world, I can get those folks involved as well. And that's probably the best way to get in touch with me, to run any questions by me if they would like.
Wonderful. And Thomas, thank you so much for leading the way on today's conversation with how we mitigate risk and bringing these to the table so that we're more aware that they're out there and things we need to pay attention to. Folks, that's it for today's episode of the Business Law, Estate Planning, and Estates podcast. Thank you so much for listening. And don't forget to subscribe, share, and leave a review. And by all means, come on back. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.